exception of Member Rosas and alternate Bulch, who are absent. We can now do the consent calendar. These items will be approved by one motion unless any member of the committee wishes to remove an item for discussion. The purpose of the consent calendar is for the committee to efficiently and quickly consider routine or administrative business items with one motion. Public comment will occur after the discussion. We invite you to submit a speaker card now if you'd like to speak on this item during public comment. Would any member of the committee like to pull an item? All right, I now invite public comments. In-person public comments will be called to speak first. And I am not a panelist. One moment. All right. We will go to Gladys. Gladys, please accept the unmute when it is offered to you. You will have 3 minutes.
Hello.
Right. Welcome,
Is it-
Gladys.
Hi, thank you. I want to speak about the landlord retaliation. Is this a good time?
This is not the time. This is for the
Oh.
consent calendar.
Oh, sorry.
That will be the first item after our appeal hearing. So I'll keep you in mind. All right, seeing no further comment, I'll now bring the item back for committee action. A motion to approve the consent calendar should include reading the title of the agenda item 3.1. Vice Chair?
I move the balance of the consent calendar, which is to approve the Rental Housing Committee meeting minutes for February 27th, 2025.
All right. Motion made by Vice Chair Ma, seconded by Member Cox. Okay. Vote, please. All right. Motion to approve the minutes passes unanimously. We will now open the meeting for oral communication from the public. This portion of the meeting is reserved for persons wishing to address the committee on any matter not on the agenda. Speakers are allowed to speak on any topic for up to 3 minutes during this section. State law prohibits the committee from acting on non-agenda items. Would any member of the public like to provide comment on non-agenda items? All right. Andrea? Okay. All right. Seeing no comments, we can move on to our first item, the appeal hearing. Now we'll switch scripts. All right, this is item 5.1, appeal of hearing officer's decision regarding petition number C 3234. I think that should be 2324-0005. The Rental Housing Committee, in hearing the appeal, is acting in a quasi-judicial fashion and will conduct the hearing in accordance with those standards. Staff will detail the appeal hearing process in their presentation. Before we get started, RHC members are required to disclose any communications they have had with any of the parties to the petition or the parties' representatives and the substance of those communications since the date the petition was filed. The decision of the RHC is to be based on the record presented to the hearing officer. Information disclosed to any RHC member that is not part of the record is not to be considered. Do any RHC members have any ex parte communications that need to be disclosed? All right. Seeing none, we will now proceed with public comment for agenda item 5.1. Are there members of the public who are not parties to the petition who would like to speak? In-person public comments will be called to speak first. Any member of the public wishing to provide a virtual comment on this item, please click the raised hand button in Zoom or press *9 on your phone. All right. We will now move to we'll proceed with the hearing. Starting with a staff presentation.
That's Nas. Yeah. Thank you, Chair.
Thanks, Naz. She can't
Oh,
hear you
wait.
if the mic's not on.
Just waiting for the slides.
I believe that is Patricia. It's a team effort.
All right. So the purpose of this item is to consider the tentative appeal decision and either accept the tentative appeal decision or modify with instructions to staff citing appropriate evidence in the record to support any modifications. So we'll go over the RHC decision process, the schedule for this appeal hearing, and then a summary of the petition and the appeal and the tentative appeal decision. So options for the Rental Housing Committee tonight, you've seen this before, but just to reiterate, to hear and decide the appeal, you could go with a closed record, which would be deciding based only on the facts and the decision written by the hearing officer, an open record, in which case you would follow a formal hearing process to potentially accept new facts before reaching your decision. And then the third option would be a remand, which is a hearing that follows closed record procedures, but in which the Rental Housing Committee may identify issues for a hearing officer to re-examine, including potentially accepting new facts if it's appropriate. As far as the role of the Rental Housing Committee, the Rental Housing Committee must exercise its independent judgment for questions of law, such as statutory interpretation. As it relates to questions of fact, the Rental Housing Committee must determine whether or not each appealed element of the hearing officer decision is supported by substantial evidence. This does not mean reweighing the evidence or relitigating the issues. In this case, the appeal is based on the record submitted to the hearing officer with no new evidence accepted or heard or considered. But this does not mean that the RHC has to come to the same conclusions as the hearing officer. So at this time, staff does not recommend a de novo hearing, as that would require significant time for the record to prepare for the Rental Housing Committee. The existing evidence in the record is sufficient, and the existing record demonstrates adequate review and ample opportunities for the parties to present relevant evidence. So the decision on appeal should be based on the hearing record, and the committee should neither hear nor find facts in addition to those presented to the hearing officer. So the scope of the appeal, as you know, the petition that is submitted by the petitioner defines the scope of the hearing officer's decision, meaning that the hearing officer should not consider anything outside of what was in the petition, the issues. And then appeals of the hearing officer's decision are limited, or limit the scope of the Rental Housing Committee's review on appeal. This means that we should only be considering those issues raised by the appellant landlord in this case, and not any issues beyond what is raised by the appellant landlord. You can go to the next slide on this one. So the schedule for this appeal hearing, we're currently in number 1, which is the staff presentation. That will be followed by the appellant's presentation, which can be up to 10 minutes, followed by the respondent's presentation, which can be up to 10 minutes. And then each party will have 5 minutes for rebuttal, followed by RHC questions for staff, the appellant, and then the respondent. And then finally, RHC deliberations and a decision. All right, we can go to the first slide on this. So a summary of this petition. This petition was a petition for downward adjustment of rent based on a number of habitability conditions, including a severe cockroach infestation, water damage, and potential mold in both the kitchen and bathroom cabinets, resulting in noxious odors throughout the apartment, rust on the bathroom mirror and the bathtub, moisture in the bedroom closet, and potential black mold on the carpet in the closet, and defective caulking in the bathroom and kitchen. So I do want to go over this petition summary a little bit tonight, because one of the issues that is raised in the appeal is just the length of this process. So this petition was originally accepted back in January of 2024. There were a number of reschedulings of the actual hearing on this decision, or on this petition rather. And so the hearing was not held until February 27th of 2024. At that hearing, there were a number of documents that had not been submitted that the hearing officer felt were necessary for her to consider and to receive before she could make her decision. And so she issued a post-hearing order that was sent to the parties shortly after the hearing was held, that had the hearing record staying open in order to allow time for the parties to submit those documents. So the hearing record was not closed until April 25th of 2024. In between April 25th, 2024 and June 24th, 2024, the petitioners actually moved out of the unit sometime in May, I believe it was May 16th of 2024. And then thereafter in June, the hearing officer was granted an extension due to a large family medical emergency and of the deadline by which she needed to complete the decision. So the hearing decision was not issued until February 7th of this year. So it is almost a year after the hearing was held. The appeal was then submitted by the landlord, timely submitted by the landlord at the end of February, and we're here in March now with the appeal hearing before the Rental Housing Committee. But I did just want to provide a little bit of background on why this process has been somewhat extended beyond what the goals are in the regulations for the petition process. So a summary of the hearing decision. So on the first issue, the hearing officer concluded that petitioners had met their burden of proof, that the moisture and mold conditions in their bedroom closet and carpet violated the warranty of habitability, and that the respondent failed to timely and sufficiently correct these issues after receiving notice. For this issue, she awarded a rent reduction of 7.5%. For the period from April 1st, 2023 through May 16th, 2024, which again is that date on which the petitioners moved out or vacated the unit. On the second issue, she also concluded that the petitioners had met their burden of proof that there existed a severe cockroach infestation in their unit, and that respondent had failed to take adequate measures to eliminate the infestation within a reasonable time after receipt of notice of the condition. The hearing officer ordered a 33.3% rent reduction for the period from June 1st, 2022 through May 16th, 2024. And June 1st, 2022 is actually the commencement of their tenancy. On the third issue, hearing officer concluded that the petitioners had met their burden of proof that the water damage to and the potential mold in the kitchen cabinets resulted in noxious odors and demonstrated a reduction in housing services, namely a failure to maintain or make repairs, and that respondent had failed to take adequate measures to correct the issue within a reasonable time after being notified. For this issue, the hearing officer ordered a rent reduction of 5% for the period from June 1st, 2022 through May 16th, 2024. On the fourth issue, hearing officer concluded that petitioners had met their burden of proof that the various substandard conditions in the bathroom, including dampness, rust, a deteriorating cabinet, and unfinished walls, constituted a failure to maintain the unit in good repair, and that the respondent had failed to address these conditions within a reasonable time after being notified. She awarded another 5% reduction for this issue for the period from June 1st, 2022 through May 16th, 2024. And then finally, as it relates to the caulking, she found that the petitioners met their burden of proof that there was defective caulking in the bathroom and kitchen, indicating a failure to maintain the unit in good repair, and that respondent made no meaningful efforts to correct the defects within a reasonable time after petitioner's notice, and awarded a 2% rent reduction for the period from May 1st, 2023 through May 16th, 2024. So on appeal, the appellant respondent, which is the landlord, raises 4 issues. Sorry about that. Okay. So the appellant respondent raises 4 issues on appeal. These are that the hearing officer erred or abused her discretion in concluding that the petitioners met their burden of proof regarding the cockroach infestation because her decision lacked solid evidentiary support and misapplied the applicable legal standards. That the hearing officer erred or abused her discretion in awarding a rent reduction for both water damage to the cabinets in the kitchen and bathroom and the odor caused by the mold and moisture conditions in the unit, because these were the same condition. That the hearing officer exhibited prejudice against respondent by omitting and considering evidence outside the scope of her post-hearing order after the hearing. And finally, that the delay in the issuance of the decision prejudiced respondent by creating potential for significantly increased costs as conditions and liability remained unaddressed for almost a year. So the tentative appeal decision recommends affirming the hearing officer's decision in part and modifying it in part. The modification is relatively small. Nonetheless, it is one that is recommended by the tentative. So on the first issue raised by the appeal, the tentative states that the hearing officer did not err or abuse her discretion in concluding petitioners met their burden of proof regarding the cockroach infestation because there's substantial evidence in the record of the existence and severity of the cockroach infestation. And this includes a number of reports from, sorry. Okay. So that this included both testimony from the petitioners as to the existence of the infestation, as well as videos and photographs submitted by them, basically from the first day of their tenancy, as well as a number of reports from the respondent's own pest control contractor that demonstrated that the cockroach infestation was widespread throughout not just petitioner's unit, but also other units in the building. And then also that the hearing officer correctly concluded that the respondent was required to correct, not just address the infestation. So while they did have pest control come out, this did not eliminate or correct the cockroach infestation, which is what is required by the CSFRA. Additionally, that it was reasonable for the hearing officer to conclude that the city's code enforcement officer met the qualifications outlined in Health and Safety Code section 17920.3 A12. Basically, this is a requirement that the code enforcement officer have received certain training before making a determination that there is an infestation of vermin in a unit. And one of the arguments that the appellant makes here is that the city's code enforcement officer who made that determination did not meet these qualifications. However, based on what was in the record, it would be reasonable for the hearing officer to conclude that the city's code enforcement officer did meet these qualifications. And then finally, the appellant challenged the date on which the rent reduction for the cockroach infestation started. And this is the piece of the hearing officer's decision that the tentative appeal decision recommends modifying. The hearing officer's decision awarded a rent reduction beginning June 1st, 2022, which is the day that the petitioner's tenancy commenced. However, the CSFRA requires not only that landlords be provided with notice, but also a reasonable opportunity to correct the issue. And so given some of the other information that was in the record about approximately how long it takes for a cockroach infestation to resolve if it's treated properly, August 1st is a more appropriate date by which the issue should have been resolved by respondent. And so the tentative appeal decision recommends modifying the hearing officer's decision to award the rent reduction for the cockroach infestation beginning August 1st, 2022, rather than June 1st, 2022. As to the second issue, the tentative appeal decision provides that the hearing officer did not err or abuse her discretion by awarding a rent reduction and refund for both water damage and odors. In essence, the respondent's argument on this point conflates two different aspects of the hearing officer's decision in Section A and Section C of that decision. So Section A concludes that the landlord's failure to address the mold and moisture in the petitioner's bedroom, closet, and carpet warranted a 7.5% rent reduction, while Section C determined that the noxious odors and deterioration in the kitchen and bathroom cabinetry demonstrated a failure to maintain the unit in good repair and warranted a 5% rent reduction. So these are two different issues which the hearing officer justified and provided substantial evidence for her conclusions in both these sections, and therefore she did not err or abuse her discretion by awarding a rent reduction for both of these issues. Next slide. As to the hearing officer's consideration of the post-hearing correspondence between petitioners and Rent Stabilization Division staff, this did not prejudice respondent. Respondent makes the argument that on appeal that this correspondence was considered by the hearing officer in reaching her conclusions that they were liable for the various issues. However, the correspondence in question, which is Petitioner's Exhibit 13, is merely correspondence between the petitioners and Rent Stabilization Division staff, wherein the petitioners informed staff that they had moved out of the unit on that May 16th, 2024 date. And so the hearing officer only included this post-hearing correspondence for the purpose of determining the date on which petitioners vacated the unit, and didn't rely on this evidence in reaching any of her conclusions that the landlord was responsible or liable to petitioners for the various issues raised in the petition. And then finally, the delay in the issuance of the hearing officer's decision did not prejudice respondent. So respondent's argument on appeal is that basically they were not able to address the issues or the conditions in the unit during the time that the hearing officer's decision was pending. However, there's nothing preventing them from addressing the conditions raised by petitioners during the pendency of the petition or any of the procedures or proceedings related to the petition. They could have taken steps at any time to address those conditions. Furthermore, the hearing officer didn't actually request an extension of the deadline to issue her decision until after the petitioners had already vacated the unit. So the respondent's liability to petitioners had already been cut off on that date that the petitioners moved out of the unit. And so the extension did not impact the award that the hearing officer ultimately gave to the petitioners, because that award is based on the move out date. And so a respondent has failed to demonstrate that it was prejudiced by the excused delay, and that and the potential for increased liability does not constitute grounds for reversing the hearing officer's decision. Fiscal impact. So any decision by the Rental Housing Committee on appeal, including adoption or modification of the tentative appeal decision, could potentially lead to litigation, which would have fiscal impacts. However, one of the purposes of appealing a hearing decision to the committee is to ensure that the decisions are legally defensible. And so the appeal process to the Rental Housing Committee reduces overall risk of legal liability and legal expenses. And then I think the final slide is just the recommendation, which is to consider the tentative appeal decision, either accept or modify with instructions to staff citing appropriate evidence in the record. Happy to take questions as always.
Thank you so much. I think we're going to get to questions for you after the address and rebuttals. So we're going to start with the appellant landlord. I believe that is Andrew. If you would raise your hand and accept the promotion, you will have 10 minutes for your initial address. Yeah. Representing, yeah.
Okay,
All
thank
right.
you.
Welcome.
Can I begin?
Please.
Okay, thank you for taking the time to hear this appeal. Many of our arguments are already included in the written appeal that was submitted, and I appreciate the City's Council for being so thorough in their response going through this. We'd just like to supplement our written appeal with some portions of the tentative ruling. I'd also like to raise some points that the landlord and property manager have raised to me over the course of this appeal. Many of the issues raised, while I understand the city's position is that they were not materially prejudicial to the landlord because the tenant ended up moving out, the length of time before we received this hearing still has caused significant issues with determining what is wrong with the unit, because it was our position or the landlord's position that many of these issues were either excessively described by the tenants or were not actually habitability violations. So without input from the city, we'd be unable to correct those. It's also creating confusion and uncertainty just in the length of time it takes to receive this response. It's been about a year. At this point, the unit's been re-rented. There's been specific issues raised with the unit. It just would be helpful to know some of those problems ahead of time. There's also it's placing the landlord at a disadvantage when they're not able to get certainty on really the rents that are going to be collected for such a significant period of time. But to go into the specifics, there's been mentioned about the standard of care here, where the landlord's responsibility is to correct the issue. And in some situations, I would agree with that. But here, one of the primary issues raised in the initial hearing was that the landlord was unable to correct some of these issues because of the actions taken by the tenants. This is addressed somewhat in the record for this case. However, one of the reasons for appeal is that we didn't think that it was given or much of any weight, specifically with the cockroaches, which resulted in a 33% reduction of rent. There was evidence presented that the landlord was unable to get into the unit to complete pest control, that food was left out, that it was making it very difficult to correct these issues. So the standard being that the issues must be corrected and otherwise there's going to be a reduction of rent. It creates a situation where if the tenant is frustrating those efforts, it would allow them to keep their rent reduced for a much longer period of time. So the attempts to perform these corrections should be what the standard is in these types of situations. And I understand the city's position that this was addressed by the hearing officer, but we don't believe it was given considerable weight or considerate weight. Moving on, there is in the hearing itself, there's also a failure to properly account for the evidence given to the extent that the hearing officer found that the presence of Orkin treatments in other apartments indicated that there was a larger roach issue present. Again, I understand that the appeal board isn't here to weigh the evidence, but one of the portions of our appeal is that the evidence presented by the landlord was not given considerate weight. And here again, the presence of Orkin treatments in other units isn't indicative of a pest control issue in those other units. It's trying to ensure that there aren't pest control issues in other units and keep pests under control. So again, this evidence that Orkin was treating the property and treating other units was used to imply that there was this considerable infestation throughout the property, but there was no evidence of that raised by the tenants in this matter. And the only evidence really is that treatments were occurring in other units, but there was no testimony by these other tenants that there either was a significant issue or if a single cockroach was found and Orkin needed to go into the unit and just do preventative treatment. It was these types of issues that really prompted the appeal, along with the length of time, just to ensure that the landlord's evidence was given a proper weight and consideration. Moving on, related to all of this, the award ultimately was a reduction of approximately 50% of the rent. It all gets broken down into smaller portions. The cockroaches were 33%. The dampness was 7.5. The failure of the caulking was 2%. Dampness, rust in a deteriorated cabinet was 5%. Ultimately, it leads to a reduction of about half of the tenant's rent. However, it is uncontested that the unit remained livable. The tenants were living in this unit. Everything still worked. The heat worked, the electricity worked. I understand that the hearing officer found the presence of cockroaches, but that alone shouldn't entitle them to a reduction of 50% of the rent. To the extent that there is any reduction, we believe that this is excessive, considering that the unit is otherwise habitable, all the rooms are usable. We've already discussed, and I know the city has also gone into the length of time that it took for the decision to come out. Again, if the tenants didn't move out in May, this would have created a situation, and this would be present for other landlords as well, where this could be a year's worth of damages of what are really contested issues of fact of whether or not there's a problem with this unit or not. Is rust on a mirror, is this deteriorated grout actually worth a reduction of rent? Here they found that it was, but it would have become a much larger issue if the tenants were still in the unit, because the landlord would have had the chance, if they determined that the city found these to be worth a reduction of rent, to go in and fix them. I understand that no landlord should be leaving issues present, but in many of these situations, these were conditions that were present when the unit moved in. And there shouldn't be a standard for a landlord to have to preemptively upgrade everything in the unit to perfect condition just to ensure that there isn't a potential for a housing claim here. let's see there. And then the final argument we have here is related to the evidence. And while much of the landlord's evidence was taken with very little weight, it does not appear that there was similar scrutiny to the tenant's evidence. There was mention in the hearing that the pictures that were taken and presented by the tenants didn't have appropriate dates on them or really weren't dated, so it was unclear at what time some of these were taken. That has not been adequately addressed. A lot of this evidence was presented just on the assumption that it was correct, but then in almost every situation, the landlord's evidence was presented and it was given very little weight. Again, this is going to the amount of the award, which we believe is excessive. Overall, we appreciate the time spent looking into this case and the going over the specifics of it again. However, it is the landlord's position that this constitutes an abuse of discretion just in the amount of the award, the way that the hearing officer has determined the evidence, and the amount of time it took to come out. We don't even necessarily believe that a new hearing would be required. However, we think that the evidence that was submitted just did not support the very significant reduction of rent that ultimately was awarded. And that completes my argument. So I'll release the last minute of my time.
All right. Thank you very much. It's now time for the respondent tenant. Please raise your hand on Zoom if you'd like to speak. This is Daria. Hi.
Hi, yes.
Welcome.
Hi, thank you.
You have 10 minutes.
Okay, so I also wanted to thank you all for your time and your attention to this matter, and wanted to thank the City of Mountain View for helping us through this process. So I guess, wanted to kind of touch on the points that Andrew had mentioned. So he mentioned that the landlord wasn't aware of the issues in the unit and to the extent of that they were. But I wanted to highlight that we did have a city inspection, and they provided a landlord with a detailed spreadsheet of what the issues were and a date that they needed to be corrected. So he had that information. And then regarding the standard of care, so Andrew mentioned that the landlord was unable to correct issues due to the tenant's actions. And in the appeal, they mentioned that it was due to our actions, and they had mentioned that there was a couple, I think it was 3 months between September, October, and November where the pesticide didn't spray inside of our unit. And one of those months was due to a very late notice from Oregon showing up, and we were going, I think it was Thanksgiving, it was a holiday weekend, so we weren't going to be there. So we only were able to only clear out half of the cabinets. And then the other 2 months, we spoke with the landlord because we found a gel bait from the store that we felt worked better than what Orkin was doing. So we were, and so we asked if we were able to just get reimbursed for that gel and then continue our own treatment. And when the landlord denied, we immediately resumed treatment with Orkin. Also, it was mentioned that food was left out, but I also wanted to highlight that they got that information from the pesticide company who came in and also showed up unannounced in the middle of the day during my lunch break. So there was food out and the trash was open because I was cooking and eating. And that situation was they came in to check the cockroach traps to see if the activity had reduced. And then I wanted to highlight that we never went to bed with a dirty kitchen and open trash. We were extremely clean in our unit because we were very adamant about trying to get rid of this cockroach issue ourselves, because we did not like living like that. And then the the landlord says that they don't know if there was an infestation, and I just wanted to highlight, which is also in the record, that we found cockroaches at all hours of the day, and usually when there's an infestation, because the cockroaches come out during the day, and we would see them. They would crawl into our food as we were cooking. I had a cockroach fall out of my hair at a public workout class. We would wake up to roaches in our bed crawling on our skin. And then we would wake up to, or we would go and see cockroaches in the laundry room. I also provided the landlord with information that health records that showed that I was allergic to cockroaches and I was extremely concerned about having them in the unit. And that was disregarded until the city of Mountain View got involved. And then when it comes to the photos, we did provide photos with timestamps of dead cockroaches the day that we moved into our unit. So there was cockroaches there before we even lived there. And we provided photos throughout the entire 2 years that we lived there, which is also in the record as well. So thank you for your time. Oh, and then I also wanted to mention that when we would discuss the cockroach issue with the assistant landlord, her name is Christy, we would express to her like how hard it was living that way. And she said that she would just kill the cockroaches with her hand and she didn't take the issue seriously as well. So we knew that if she was used to living with cockroaches and killing them with her hand, that there was like a bigger issue. Yeah. Um, yeah, and she lived there as well. She lived like below us 2 units down. And that is all I have. Thank you all for your time.
All right, thank you. We'll now return to Andrew. You have 5 minutes to rebut any statements made by the respondent. Please limit your comments to rebuttal rather than repeating information already presented.
More rebuttals.
Okay, thank you. I understand that the appeal board is not in a position to be weighing the specifics of any new evidence presented. I would like to mention that in the city inspection that is in the record, there was notes of an open bag of dog food and water left on the ground. So there has been evidence in this inspection as well of the unit not being properly prepared for pest control treatment, just which I'm mentioning to highlight the fact that of the evidence in the record, there was facts presented that there were issues with completing the treatment, which we believe should at least reduce the amount of the award to the extent that there was a finding. However, our request would be that there be obviously a new hearing on this matter. Otherwise, I don't believe it would be productive to get into the specifics of the back and forth evidence, as I know this was already addressed in the hearing. So that's all for the response.
Thank you. And Daria, you also have 5 minutes to rebut any statements made by the appellant. Do you have any further rebuttals?
My fiance will speak.
So I'm also part of the appeal process. I was living there with my fiance. Yeah, I just wanted to like recount. My point was like one of the worst times that I had when I was living there was waking up to the cockroaches in my sleep. Like so, like it was an infestation that was so bad. Like you would get woken up by them. You know, they had time to get into Daria's hair as she's sleeping. You know, they're crawling on me when I'm sleeping and I wake up to them. I mean, even to this day, we still sometimes we see like something move at the corner of our eye and we like look right away at it because we think that it's a cockroach. So you know, we take this matter like very seriously and we just want to thank you guys for taking the time to review this case. And yeah, just thank you. Thank you guys for your time.
All right, thank you. We will now return to RHC. RHC members, do you have any questions for staff? Member Cox.
Yes. I was just wondering, I think this is the first time I've heard a case where, I mean, that there was the city inspectors were called to look in on the unit and make an evaluation of it. Can you give me some more context about how that goes? Is it just that any tenant can call the city for an inspection and they just, I mean, that they respond, they come out, they give their, evaluation of the situation? Do they have the power to order things to be done, or how does that go?
In cases, sometimes tenants ask for an inspection, but then it's up to the inspection officer to determine whether or not this is necessary. But also, hearing officers can ask the inspector to go out for an inspection.
Which was it in this case?
Patricia, do you remember? I thought it was the hearing officer.
I believe it was the hearing officer.
Okay.
So to further clarify, the city has a multifamily housing inspection program that provides inspections to multifamily units throughout the city. They do this on a rotating basis in general, and then can be requested by both property owners and tenants at any point through calling a phone number or reaching out to the multifamily inspection program on their own. I believe in this case that the hearing officer did request the inspection, and that is how we ended up with the report. So there's an extensive report that's given if there's violations on the property, and then the property owners are provided a certain amount of time to address those issues without fines. And if they do not address those issues without in the timely manner as required by the inspection report, there can be additional consequences.
So,
Okay.
sorry, I just want to correct something really quickly here. So in this case, there was a follow-up inspection that was ordered by the hearing officer, but one was actually completed in June of 2023 of this unit, which is before the petition was submitted in December and accepted in January of 2024. So this actually took place and was sent, and the landlord admitted at the hearing that they knew of the city's inspection report no later than July of 2023. So it was actually beforehand. And I believe that the tenant had just called in at that time to report various issues with the unit, and an inspector had come out in order to check that. But there was also, I believe, a post-hearing inspection that was done as well.
Okay. I thank you so much. And I have one other question. I listened through the entire hearing in 3.5 hours worth, and yet at the end of it, I mean, it was unclear. I mean, some of it, in my opinion, but I thought I also heard this too, that, I mean, all the evidence that one would need to make a really good decision even wasn't evident at that point. In particular, some of the evidence had redactions in the records that made, it not clear where and how, the cockroaches were appearing in which units and that kind of thing. And it seemed to me at the end of it, what happened was the hearing officer had to go after the hearing in order to get additional evidence to be able to make her conclusion. And so I'm just wondering, can you say a little bit more about the process of what is allowed to be gathered, after the hearing itself in order to be able to make a conclusion?
So typically the hearing officers during the hearing, which I'm sure you heard on a number of occasions as you were listening, they will say, if you're using that document, for instance, to refresh your memory of what happened, then they're going to ask for them to submit those documents. So typically what happens is that the hearing record is left open after the hearing, and the hearing officer will issue a post-hearing order directing the parties as to what types of evidence they need to submit and the date by which they need to do so. And then anything that's submitted that's beyond the scope of what is in the order, will not be considered. But I can't say specifically what types of evidence. It really depends on what the hearing officer's order requests. But in this case, there was a lengthy, I believe it's like a 16-page post-hearing order that requested a number of documents, including the landlord's notes, as well as those unredacted pest control reports, as well as a number of other items. It's my understanding that several of those documents were not submitted despite the post-hearing order.
Okay, so then after all that is submitted, does the other party also have the ability to see this information before, the appeal hearing? They would, right?
So typically the evidence that is being requested is something that they've already had an opportunity to address during the hearing. It's something that the testimony probably relates to testimony. In this case, because there was so much evidence that was being requested after the hearing, I do believe that the hearing officer provided a certain amount of time for the parties after the documents had been submitted for them to submit briefing addressing any of the documents. So it wasn't another hearing, but it was an opportunity to provide something in writing addressing any of the documentation or evidence that was submitted as a result of the hearing officer's post-hearing order.
Okay, thank you. Those are all my questions.
Thank you. Vice Chair?
Thank you. And this is going to be relatively irrelevant for the appeal today, but for future cases, do we have a procedure to address situations where we expect the hearing officer to take more than expected in the timeline to make a decision?
I do know that in some cases, and I'll let staff provide a more thorough answer as they do the administrative process, but in cases where, you know, this has happened at times, it has been assigned to a different hearing officer to do to draft the decision if there's going to be a lengthy delay.
We have different procedures that are available. And in this case, there was an extension based on the needs of the hearing officer and the family emergency at the time.
Okay, just checking. Thank you.
Thank you. Any more questions for staff? All right. Any questions for the landlord or tenant? Member Keating.
I'd like to ask a question of the tenant.
All right. Daria, still on the line?
Yes, I'm here.
Go for it.
So when you moved out, I'm just wondering if the level of roach infestation had gone to zero or was still present.
Oh, it was still present.
Thank you.
All right. Any more questions? The RSC will now deliberate. It would be appropriate at this time to entertain a motion to adopt the tentative decision, after which time such motion can be discussed by the RHC. Member Cox.
Yes, I'll make a motion to support the tentative appeal decision in its entirety. And I'll give you, motion? Yes. Motion. Okay, there we go. Sometimes if you motion twice, it unmotions it for you. Okay, let me give you my reasoning on this. And I want to make a few other comments, because I think it's useful to make some comments for the record so that if, people who are going to make an appeal have the opportunity to look back on other appeal hearings, they can learn something about what matters to us, or at least to me, okay? Anyway, first, I just wanted to say something about, redacted evidence. And, I want to encourage parties that submit documentation for a petition or an appeal not to redact information unrelated to privacy that is germane to the consideration of the hearing officer. I understand redaction of information by the appellant in documents that he submits it's fully justified for him to remove any personal identifying information, and so that other private information like medical information or names of tenants that so that that is not inadvertently disclosed. However, in this case, I think it was important to know which other units might have had a cockroach infestation. Knowing that helps you determine the extent of the problem and whether other units are in the proximity of the unit under review are experiencing the same problem. And so, I mean, that was something that I felt that if that information had been presented up front, it could have been easier to see what was going on. A second thing that I think is important to note, and we've seen this in previous appeal hearings, is a recognition that attempting to cure a problem is not the same thing as curing the problem. And the CSFRA makes it very clear that when a habitability problem comes up, the landlord is required to cure the problem in order for it to be resolved. I think the fact that almost half the units in this landlord property had been treated for cockroaches in the last 2 years shows this is a serious, pervasive problem, which may require treatments beyond that which were routinely applied in the past. It's my hope that this landlord will seek out a more effective treatment that will cure the problem in all of his units. And then the last thing I just want to say is I support the reduction in the award on the cockroach issue to reflect the need to give the landlord an appropriate time to cure the issue before assessing penalties. That also, as it was pointed out in the tentative appeal decision, is a requirement of the CSFRA. I think the 2-month time is a reasonable one. I mean, it's not like changing a light bulb that you can do it, a day later. I mean, and particularly in this case, I mean, it seemed like a very deep problem. I did raise an issue in written questions to the staff about whether the time needed to cure the issue also needed to be reflected in the water damage and odors in the kitchen. Staff gave a response saying in its appeal, the appellant landlord challenged the hearing officer's decision to award a rent reduction beginning in June 2022 only as to the cockroach infestation. The landlord did not raise the same issue with respect to the water damage and odors in the kitchen. Since the landlord is represented by legal counsel, staff determined the landlord could have equally appealed the issue with respect to the water damage and odors, but decided not to. I'll just say I personally didn't find this fine distinction to be that obvious, but I am also okay with the staff response. I think it's a reasonable one, and if the other committee members are also in agreement that it's a reasonable response, I'm okay with it. So that's what I got to say.
All right, thank you. So the motion was made to approve the tentative appeal decision in its entirety by Member Cox and seconded by Member Keating. Do you have any further comments or deliberation? I also support the tentative appeal decision. Oh, Naz?
Yeah, I just wanted to quickly mention this before you all take a vote on this, but there was the version of the tentative appeal decision that's in the agenda packet is not the correct version. That had a couple of errors. A new version was sent out last Friday to the parties as well as the RHC, and so I just wanted to make sure that everyone was aware that that is the version that should be under consideration. I don't know if Karen, you think that we should include it in the motion just to say it's the version that went out on.
I would be happy to ask
March.
Robert to read the full text of the.
No, we don't need to do that, but we can just clarify that you are approving the corrected version.
Yes, that's my intent.
And seconder?
I appreciate the clarification.
Okay. So yes, I also think that we need to acknowledge that there should be an opportunity to cure and that should be reflected in the decisions. But also that it does need to be cured. That you don't get credit for partial work. Vice Chair?
For the purposes of utmost legal clarity, can we specify what the actual clarification is for the amendment? Because I believe the current version on Legistar still has omissions.
Yeah, Naz, can you walk through the correction?
Yeah, there were a number of just typos, namely,
I think it's mainly the award amount.
yeah, it was the award amount. There was a placeholder there for the calculation. If you look at the last page, it says like XXX instead of an amount, and an amount has been inserted that is the sum of sections A and B.
Thank you.
All right. I believe it is now time to take the vote. The motion passes unanimously. Thank you, everybody. We can go back to the standard script. We will now move to agenda item 6.1, study session, tenant anti-harassment and retaliation protections. Public comment will occur after the presentation item and committee questions. We invite you to submit a speaker card now if you know you would like to speak on this item during public comment, or raise your hand if you're in Zoom. All right. We will begin with the presentation from staff.
Thank you, Chair and members of the Rental Housing Committee. This next item will be a study session on tenant anti-harassment and retaliation protections. The goal for today is to provide, for the Rental Housing Committee, to provide direction to staff on potential local residential tenant protections against harassment and retaliation, and to determine next steps. The Rental Housing Committee asked staff to include a study session on tenants harassment and retaliation protections in its work plan of 22-23. Tenants over the years, particularly vulnerable tenants like seniors, disabled, and undocumented tenants, have reported certain behaviors such as threats, coercion, fraud, or intimidation that could constitute harassment or retaliation. Some examples that were reported are to interrupt, reduce, or terminate housing services without cause, force existing tenants to agree to new material terms of tenancy not allowed under the CSFRA or MHRSO, avoid making necessary repairs or maintenance, avoid complying with notices or order to correct a violation in a timely manner, evict tenants, such as by misrepresenting information, refusing to accept or acknowledge receipt of rent payment, preventing payment of rent, etc., and prevent tenants from forming or taking part in a recognized tenant organization. So what does we mean with harassment or retaliation? Harassment is the use of certain methods or behaviors by a landlord, such as threats, coercion, fraud, or intimidation, to prevent a tenant's exercise or assertion of their rights, or to interfere with a tenant's use and quiet enjoyment of the rental unit, or common areas or services, or generally make the tenant's life difficult. An example of harassment is that a landlord may turn off the tenant's water or electricity because they want the tenant to move out of the unit so they can charge a new tenant a higher rent. Retaliation, on the other hand, means that certain methods or behaviors are used by a landlord against a tenant in response to the tenant exercising certain rights related to their rental unit or tenancy. An example of that would be that a landlord may turn off a tenant's water or electricity as a response to the tenant complaining about substandard conditions in their rental unit. And both are related issues conducted by landlords that negatively impact tenants. And it is recommended that the Rental Housing Committee address both types of behaviors if it wishes to adopt certain tenants' protections. There are certain federal and state fair housing laws that exist relating to harassment and retaliation, but only in cases a tenant is discriminated against if the tenant is a member of a protected category. This could be race, income, familial status, etc. And tenants must prove that the discrimination was intentional, which can be difficult. Separately, there is a California landlord-tenant law that provides some anti-retaliation protections for tenants. These are related to limited actions of tenants exercising their rights, and remedies are also limited. Adopting local anti-harassment laws would provide broader protection for tenants exercising their rights under the CSFRA or MHRSO, as well give additional remedies. So staff conducted an initial evaluation of other rent-stabilized local jurisdictions in California that have adopted anti-harassment and retaliation protections. Most are adopted by ordinance and apply to all residential tenants in the city. These local laws protect vulnerable tenants, prevent involuntary displacement, and prohibit illegal evictions using fraudulent or misleading representations, intimidation, and coercive conduct. The local law also applies to all tenants, regardless of any protected categories under federal or state law. And these local laws protect clear definitions of what type of behavior constitutes retaliation harassment, which makes it easier to understand for both landlords and tenants. And they provide additional enforcement mechanisms and remedies. The Rental Housing Committee has authority to adopt regulations that address harassment and retaliation to further the purposes of the CSFRA and MHRSO, because the intent of both laws is to prohibit any actions by landlords that would result in arbitrary evictions of tenants, protect tenants from unreasonable rent increases, and provide avenues for tenants to exercise their rights to enforce CSFRA or MHRSO protections. As you probably are already aware, the Rental Housing Committee authority is limited to adopting regulations applicable to CSFRA and MHRSO covered tenants only, and protections for all tenants in the city can only be achieved by a council-adopted ordinance. Providing further protections for anti-harassment and retaliations also sync with the City of Mountain View's strategic roadmap as a community for all to support Mountain View's socioeconomic and cultural diversity, to engage and protect vulnerable populations through policies that promote access to housing, transportation, and other programs and services. And it also syncs with the Housing Department mission of the City of Mountain View, which is to advance diverse, inclusive, and equitable communities by developing and implementing a wide range of housing policies and programs related to affordable housing, rent stabilization, and tenant protections. So today, the city has adopted a variety of policies and programs already to protect the safety, health, and welfare of residential tenants, such as the CSFRA, the MHRSO, and Tenant Relocation Assistance Ordinance, the Mountain View Mediation Program, and the Housing Help Center. And adoption of anti-harassment and retaliation regulations will provide additional tenant protections. So regulations would include the following key components: definitions of harassment and retaliation, the types of harassment and retaliations that would be included in this regulation, such as quiet enjoyment disturbances, habitability violations, misrepresentations, rent payment violations, privacy violations. It would also include noticing requirements and remedies and penalties. So the question for the Rental Housing Committee today is if you are interested in developing an anti-harassment and anti-retaliation regulation for tenants in CSFRA and MHRSO covered units, and if so, does the Rental Housing Committee agree with the following scope of work: further analysis, further review of comparable jurisdictions, a study session to discuss this further analysis, and a meeting for Rental Housing Committee consideration. This is the end of the presentation. Happy to answer any questions.
All right. This is the time for questions from committee members. Does anyone have any questions for staff? Yeah. Yes. So questions, then public comment. then deliberations feedback. No question? No. Member Keating?
So with the regulations we now have, if there's a problem, then it generally results in a petition. And so would hearing officers be involved? Would, how similar would it be for, if there was a harassment or retaliation situation?
Yeah, so not all harassing or retaliatory behavior can be considered a housing service. So that's why we would like to hear the Rental Housing Committee's interest in providing additional protections for tenants.
So as focusing on those additional protections then that couldn't be handled or wouldn't, be a housing service, would a possibility or a likelihood be that they would also, that we would have an ordinance that would again direct them to hearing officers?
So there may be some instances of harassment that would constitute a reduction in housing services, and those could be addressed with a hearing officer. For other areas of harassment, most likely the tenant's rights would be to proceed in court for an order enforcing their rights. It can also help with an affirmative defense against an eviction action. But I don't think we're envisioning that the Rent Stabilization Division would mediate or, adjudicate these disputes, except for the instances where they fall into a reduction of housing services.
Good for now.
Member Cox?
Yes, in the questions, and answers that we had, that were sent to us, questions by the Rental Housing Committee members and answered by staff before this, meeting that we've had here. Okay, thank you. That makes a difference. You noted that one of the things that we might be able to accomplish is establishing the amount of a damage award to which a tenant may be entitled if a court finds that they have experienced retaliation or harassment. Could you expand on that a little bit? I mean, and like, how would the language actually get written up for something like that?
Right. So that will come in our further analysis for you to consider. But looking at other jurisdictions, they give a certain amount for each violation, and that can be determined by the Rental Housing Committee in their regulations. And you can also determine what the general damages are when it is presented in court. Karen, do you want to say?
Yeah, so we could establish that the schedule for damages, we can't award damages. That it has to be done by a court. But, if a court were to find that the property owner violated the regulations, then that would give the judge parameters for the damages award.
So, I mean, would, like, for example, how many different violations, specific ones that happen, play into that? Would it be like over how long a period of time a certain behavior occurred? Would those be some parameters that might play into the amount?
Right. Also, there could be, if the harassment was malicious or repeated, there could be treble damages. It
I see.
depends. I mean, those are things that we would have to look at in terms of drafting the regulation.
Okay, just wanted to get a general idea of what you had in mind. Thanks.
Vice Chair?
Thank you. Question to staff. So the memo mentions that Project Sentinel is kind of the go-to for in cases people have questions about retaliation, harassment, but not necessarily ready to do a petition. I was wondering, how would an average tenant know about that resource? Is that something we show at the Housing Help Center, or?
We do, and Project Sentinel only takes cases of federal and state discriminatory behavior. So that's not all forms of harassment or retaliation.
And we cannot increase that scope of work, or can we?
Well, based on what?
As in, like, if we make regulation
Oh, well, they then represent the tenant in court.
Okay,
So
so-
it just will always be a court process.
But
So
based on our regulation or based on federal and state?
right now, based on federal and state regulations.
But can it include a regulation, or that's separate from their work?
Yeah, so several legal agencies can decide to represent tenants in court.
Okay.
Yeah.
And separate question, for the scope of work proposed, does that include the potential of sending a recommendation to council?
That is up to the rental housing committee to decide.
Do we need to be explicit about that today, or that can be brought up at a future meeting?
Again, I think that is also up to the rental housing committee to decide. Do you first want to go forward with this proposal? If so, do you first want to adopt regulations and then make a recommendation to the council, or do you want to do that today?
Thank you.
Member Keating.
So I want to check my understanding. So right now, federal and state regulations allow some people to, or some situations to take harassment situations to court, but not others. And we would be expanding the range of who could take a harassment case to court with our regulation.
That's correct. Federal law really only protects based on discriminatory actions. So one has to be a member of a protected class, and the actions have to be discriminatory in intent. State law does have some retaliation protections, but they are more limited. So you would be expanding the protections.
All right, if there are no further questions, we can move on to public comment. We will take in-person public comment first. Andrea?
So first we have Perna.
And you have 3 minutes. Welcome.
Thank you. I'm so glad you guys are here. I've been a resident of a rental unit at a spiritual community called Ananda, and I'm 2 months short of having lived there for 5 years. It's been a nightmare, to say the least. I'm a single woman and now probably in a protected class because I'm 60, so considered a senior. But they have harassed me, given me really poor maintenance. A few things that I'll quickly just bring to your attention is one, when I moved in June 1st, 2020, I noticed a month or two after being there that my electricity bills were inexplicably high. So maybe they thought me being a single woman and I have a very soft personality, they didn't think I would approach them, but I went to the management and said, my bills are really high. Is something connected to my apartment? And they kept denying it. I kept trying to do all kinds of research, couldn't find it. Finally, after many months, I called PG&E, and they said, I went to the apartment manager and said, I've called PG&E, they're going to come to evaluate. And instantly, the manager said, we'll take $20 off, $15 off your monthly rent. So at that point, I knew something was connected, and I now find out they've been using my electricity, and I've been paying the rental community office bills for almost 5 years. The other thing that happened was there were a lot of maintenance issues that were not being corrected appropriately. I won't have time to get into that, but another thing that happened was in November 2023, the first week, I noticed that the manager made an entry into my apartment without any notification. And when I confronted him, I was really sort of feeling violated and scared. And when I finally met up with him, saw him and confronted him on that very politely, he told me to get out of the community. And since then, I have raised many of my concerns with the leadership of that community, but they're a spiritual community and I don't belong to their spiritual group. So they gang up together, they do social isolation. I have been told by 3 other members of the community, we're surprised you're still staying here. One of them gave it to me written up in an email, that you seem very refined and I think you'd be happier somewhere else. I'm running out of time, but it's a laundry list and they have been unfair to many residents. I'm just glad you guys are here.
Thank you.
All right, thank you. Next, we'll move to Zoom, and I'll ask Anil to unmute yourself.
Good evening. My name is Anil Babar with the California Apartment Association, and I just wanted to reiterate the fact that the state has many existing protections against harassment and retaliation, preventing the need for local jurisdictions from enacting parallel legislation. State law provides these protections and methods for enforcement that negate the need for a municipality from having to engage in this arena. Notably, the Fair Employment and Housing Act prohibits practices that intentionally discriminate, as well as practices that may not intentionally discriminate but may have a discriminatory impact against a protected class. And I should note that there are avenues for enforcement. The staff memo states that tenants must prove discrimination is intentional. However, that's not entirely correct, because if they file a complaint with the Civil Rights Department, the Civil Rights Department then becomes the one that investigates the complaint. So there are a number of avenues to file these complaints. And I want to further note that based on the staff report, Project Sentinel has handled only 10 cases of the city of Mountain View in the past year. With so few cases, the need to enact parallel rules is negated. Rather, I think the more appropriate course of action should be further education of the tenants in Mountain View of the existing rights under state law, to see if that addresses a need for informing the tenants of what their rights are. Personally, CA is committed to educating our housing providers on the protections afforded to tenants under state law, in the effort to further promote fair housing. In closing, education should be the first step before unnecessary and parallel legislation is considered. Thank you.
Thank you.
Thank you. Next, I'll ask Gladys to unmute yourself.
Hi, hello. My name is Gladys, and I have lived in Mountain View all my life. Mine is my college years. In the last years, my neighbors, family, and I have experienced firsthand retaliation, and unfortunately, I think the instances will continue. I'd like to share this case. So almost 2 years ago, we had a situation at our small apartment complex that resulted in us not having hot water for days and then no heat. This is a unit that includes children, disabled adults, and seniors. Upon recommendation of a city official, we looked into our renter rights. We requested inspections of livable conditions, and many problems were found. Inspections had not been done in many years. Some neighbors moved forward with the petition process with the help of the city. What has followed since has been unacceptable and disrespectful actions from the management company. Incompetent vendors have been sent to make repairs. Vendors who come out at very early times. They use our property, they jump through windows, they create a mess of trash and nails, and often do subpar work, resulting in ongoing complaints to management. Some vendors have even intimidated us, telling us we made a mistake by filing the petitions because our landlord has often been sued but never loses. This is the same vendor who told us that we were treated differently from prominent white tenant complexes. We are all tenants of color, many of us essential workers. In addition, the landlord has discarded property of ours without notice as he prepares for inspections. One of these times, I told him to please return our property, and he disrespectfully refused. He has even had his lawyer tell us that the costs that were required for the repairs, like the roof, which was leaking, would be passed on to the tenants. During inspections, management would take pictures unrelated to the repairs to then use in petition responses, forcing us to be present during these walkthroughs, meaning we had to take time off of work. This is common practice as they do not ask for our hours to get repairs done. They're often done in a last minute and an erratic fashion. In the last 2 weeks, I'll share that one of the units was being repaired for the petition process. The vendors came, I kid you not, at 9:30 p.m. on a Saturday and worked until past 3 a.m. on Sunday. For over 5 hours, there was hammering and wood cutting. 3 different neighbor units told them to please stop, and they did not. I myself called Mountain View Police Department, but they said there was no noise ordinance and they did not come out. I'm sure the landlord is not the only bad actor in the city, and it's unfair that when we assert our rights, we're mistreated and forced to put up with these situations. Fears of intimidation may lead us to not speak up. So I want to thank you for considering this today.
Thank you. And then last call. All right. I believe that is the end of public comment. We will go to committee deliberation and feedback. I'm sure. Oh, Vice Chair.
Question to staff, given one of the commenters. What is the scope of a compliance hearing if there's been a potential lack of urgency done on something that was directed by a hearing officer previously?
That's an interesting question. Usually the awards state that for as long as the violation lasts, there will be a reduction in rent. It doesn't, I haven't seen cases where it says if the repairs have not been done in such and such months, the reduction will be even further.
Yeah, because I just wonder from at least for that particular comment about if in the process of trying to correct something, it causes further reduction in housing services, in which case that may, I mean, normally would require a fresh petition, but I was wondering if there's anything that could be done in those cases.
No.
Okay.
Yeah.
Member Cox.
So this is time to make comments like for deliberation.
Questions?
Just questions.
Comments, deliberation.
Anything. Okay. So
motions, straw polls.
Right. So I support the work item. Let me tell you why. Okay. I mean, thank you first to staff for the excellent background information on this and other jurisdictions. Went through, did some math. About 3/4 of the California rent stabilized jurisdictions cited by staff in attachment 1 have some form of anti-harassment and retaliation policy. And I think we should too. But the thing that motivates me most is that is the recognition that particularly when rent control is involved, a landlord can have a financial incentive to remove a tenant from his unit if the rent is lower than the market rate. So we need tenant protections to ensure that harassment and retaliation are not employed to this end. And that needs to be, that's a consideration for all people, whether they're part of a protected class or not, because I mean, you know, the financial incentive hits everybody regardless of, you know, any pre-existing legal benefit they might have. Anyway, in the appeal hearings that have come before us, many of the tenants have held off submitting a petition on a problem with their landlord until after they have left the landlord's complex. And to me, this is evidence that they may fear retaliation from the landlord because they filed the petition. Ultimately, the delay in filing the petition can actually work against the landlord's interest as well, because it can lead to higher awards against the landlord than would have happened if the petition had been filed earlier. So I think having explicit anti-harassment retaliation protections can be a win-win both for landlords and tenants. So in particular, I thank staff for the answers that we got to pre-submitted questions. I think it's great that they've singled out that this can help landlords and tenants understand their rights and obligations and provide guidance to court that may be considering a claim for retaliation and harassment, establish the amount of damage awards, and also to offer protections as an affirmative defense against an eviction action. I also support, you know, after this is all done, you know, I think it'll be quality work, and I think I will support having the council take up citywide protections on their schedule. I'd want to see it first, but I think, whoever submitted the question, I think that was an excellent idea to bring up. So thank you.
Thank you. Vice Chair?
Question for legal counsel. We in regulation cannot authorize equitable relief on this topic, can we?
Most likely not, but what are you thinking about?
Oh no, I'm just wondering, like in a way, we would like to penalize such behavior, but I don't want it to be the case where, there's just a standard damage table and they just kind of treat that as a cost of business kind of item. So
Yeah, I think we are limited in what we can do.
Member Keating?
So I support looking at this, and it's with a little bit of a sigh that I think part of the habitability issues that can go before a hearing officer rather than go to court bring a lot of accessibility to the process. And would it be correct to expect that someone going to court would need to have representation?
Most often, but if, there are options for people to represent themselves, and also there's obviously small claims court, which I think has a limit of 5,000, but I can never keep track. So,
okay. I'll be supporting letting this move forward. And I have mixed feelings about if, we should recommend it to council first, or if we should pursue it for the areas where we have the ability to implement it ourselves first. I'd be open to either.
Yeah, I will also mention in that regard that the council is working on their own work plan for the coming 2 years. I think in April they will make their final decisions. So it might take a while for that topic to. Yeah.
Thank you for that reminder.
Vice Chair?
thank you. I'll give my thoughts now. So yes to both of the questions. Yes, I am interested in developing anti-harassment, anti-retaliation regulations. And yes, I agree with the scope of work. With regards to council, it was never an intention that we would go to council first on anything. We need a slide, so it's fine. But that we should, given our relative speed, we
Thank
should
you.
be able to get to it first. And then if there is any if there's any discovery about the limits of our powers, then in the future we can bring it up to council.
My turn. I also strongly support exploring this. I think that this is something that we have heard from enough people that I think that it is a concern in the community. And education is great, but I think that we have the power to locally set rules and things to protect the residents of Mountain View in a way that they know that they are supported and taken care of by us, by the city. And so it's not a question to me whether or not we should do something if we can help make people safer and also make them feel safer. And I trust our staff to do the exploration and find the limits and what we can do. In terms of the other cities that have protections, I'd like to see if we can go as far as we can, try to meet or exceed the protections of other cities, because I do think that there are perverse incentives that we would like to combat with this when it comes to rent control and mitigating any potential harms. But also, again, the focus should be on keeping people safe and helping the landlords, because if there's someone out there who is claiming harassment and you are a housing provider who knows you're not doing anything wrong, there will be bright line rules to be able to say, I am not harassing or retaliating because here is the rubric. I'm on the right side of this. Whereas now it is ambiguous. There could be dispute as to whether or not any given action does constitute harassment. And having codified regulations in place protects against that. So I'm for it. Okay, so the scope of work, analysis, comparable jurisdictions, study session. And I do think that when we bring it back to the RHC for study session, I would appreciate something about what could be brought to city council or included in their future work plans, just as an aspect of the report. I don't think we need to wait to get into the work plan to do something. I think that we can get it started and just make sure that it's extensible and that anything that we do can be extended to other units at the direction of city council if they chose to enact an ordinance. So I don't think we need a formal motion for this item. You got all the direction you need? Yeah. All right. Yay. So that was easy. Thank you, committee members and staff. We'll now move to committee staff announcements and updates, and I'll hand it back to staff for presentations.
Thank you, Chair. All right, so we'll move on to agenda item 7.1, where we'll look at upcoming workshop dates and help center dates. Right, and as usual, we do continue to do our virtual office hours every Tuesday from 10 a.m. to noon, and those are online at the website there for people to register. That's open to tenants and landlords and any community member with questions. And you'll see our upcoming workshop schedule there. We have one coming up April 10th at 2 p.m., which is virtual only and landlord focused. It's going to be looking at submitting the utility adjustment petition. Following that is April 17th at 2 p.m. This will be open to all and it will be online. And we will be discussing accessibility and accommodations, and we will have a guest presenter from Project Central's Fair Housing. And just closing out April there on the 24th, we have our 1 p.m. slot at the Senior Center after lunch, where we'll be talking about Rent Stabilization 101. And we continue to have our Landlord Housing Help Center. We're continuing the every Thursday dates at this point because we do have an increased volume of landlords coming to see us for help with petitions and some people still with registration and fee payments. So we are continuing that every Thursday at this point, online and in person. And our Housing Help Center for tenants is on its regular schedule, which is the first and third Thursday of the month. Again, that's online and in person. That's from 6 to 8 p.m. We have our staff there. We also have other organizations, including CSA, for people to learn about other resources, including rent assistance. We have another staff member from the housing department who talks about affordable housing opportunities. And we also have a representative from CLUSPA looking at legal issues that tenants might be facing with their landlords. And that concludes upcoming outreach and workshops. Any questions?
Are there any questions?
Also, we have scheduled our summer kickoff.
May 17th?
Yes, May 17th. So we will.
I'm not super excited for it.
We're just finalizing the flyers and all the outreach. So that should be coming to everybody soon. And we'll be doing a big outreach push for that. It should be really good this year, as it is every year.
I am actually very excited for it. Are there any questions or comments from committee members? No? All right. Then we can announce the next agenda items. Yep. So Thursday, April 24th, we'll be electing our chair and vice chair and announcing the annual adjustment of rent. And no hearings?
Not at this moment.
All right. So the public can look forward to a quick, exciting meeting.
Don't say that.
Oh. All right, item 8. The meeting is adjourned at 8:41 p.m. Next Rental Housing Committee meeting is scheduled to be held on Thursday, April 24th at 7 p.m.